Thank you, Your Honor. We are present in State of Ohio versus Roxanne Badkar on case number 25 CR 513. We are here today for purposes of sentencing. We were last here on June 6th when the defendant pled guilty to count 1, illegal use of a minor or impaired person in a nudity-oriented material or performance, a felony of the 5th degree, and count 3, disseminating matter harmful to juveniles, a felony of the 5th degree as well. The court referred the defendant for a pre-sentence report and psychological evaluation and victim impact statement. Those reports have been completed and the state's prepared to proceed with sentencing.
You will be required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if you are temporarily domiciled for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education, if that's applicable, immediately upon coming into that county. If you establish a place of education in another state, but maintain a residence or temporary domicile in your home state, you will be required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. Now, your failure to register, your failure to verify your residence at the specified times, or your failure to provide any notice of change in residence address or other required information will result in further additional criminal prosecution. You understand that?
Yes, sir.
All right, do you have any questions for me regarding these responsibilities or requirements that you're going to be obligated to follow?
No, sir.
All right, then I'm going to hand you at this time, my bailiff will hand it to you, the form I just read to you. On line 11, it reads, I acknowledge that the above requirements have been explained to me and that I must abide by all the provisions of the Ohio Revised Code, Chapter 2950, which is the section of our revised code that sets forth what I just read to you. But again, this is acknowledging that I read it to you and that you understand yet you have to follow those, what I read to you. All right, with that matter having been addressed, Ms. Tomazik, is there any reason we should not proceed to sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Is there anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We'd like to ask the court today to allow Ms. Badkar a chance on community control sanctions. Speaking of Ms. Badkar, she has no criminal history. She doesn't even have a traffic offense. This is her first time ever being in trouble. Ms. Badkar and I have had many conversations. It's clear to me that she, throughout this entire process, has been very scared. Based on my conversations initially, it took her some time to fully understand the severity of these charges. It took some time to build up rapport because, like I said, she's never been in this situation before. So it did take some time for her to build that rapport with me and be able to admit what happened and understand the severity of it. I think she is still having a little bit of a difficult time with it. Her entire support system is in Illinois, so if Your Honor would allow her community control, we would ask for it to be transferred to Illinois, to her hometown. In speaking with Ms. Badkar, every time I've seen her or talked to her in the jail, she's been very upset. I think she has a much better understanding now of how severe her consequences can actually be. She knows she lost her job. Her main priority is to find a new job and get home to her kids, to be a support system for her kids. Her 14-year-old son, Ms. Badkar is the only parental figure in his life. She does live with her friend Rebecca and one of the other kids' fathers, but overall with the parent, Ms. Badkar is the only parent for her 14-year-old. I've received letters from her family and some of her close friends. I did forward those to the court. They describe Ms. Badkar as a person who's willing to help others as best she can and to advocate for others any chance she gets. They describe her as a loving mother and friend and willing to do anything for anybody. So we would just like to ask to allow Ms. Badkar a chance on community control. She's fully, at least with me, she is fully aware how serious her conduct is. And like I said, I think she's just had a very difficult time with this because she's never been in this situation before, so she has a hard time building that rapport with others and admitting to what has happened here. Thank you.
Thank you. Ms. Badkar, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I'm sorry for what I did.
What'd you do?
I sent inappropriate photos to an underage child. I'm sorry for what I did. Am I allowed to address his mother?
Sorry?
Am I allowed to address his mother?
You can say whatever you want to say.
Kelly, I'm sorry. I can't. I can't take back anything. I apologize for the things that I did. All I can do is be a better person. I'm sorry. I know that doesn't change anything, but I apologize to you, and I'm not mad at you for what you did. I'm sorry. I would like to go home to my children. You hold my life in your hands. I'm petrified. I don't want to go to prison. I've never been in trouble. I will do whatever you ask me to do. You want me to do backflips in my backyard? I will do that. I don't care. Whatever you ask me to do, Mr. Claude, I will do. Just give me a chance, please. I have a 6-year-old, an 8-year-old, and a 14-year-old.
A 14-year-old, right?
Yes, sir.
The same age as the boy involved here.
I know.
What if someone is doing what you did with this 14-year-old boy to your 14-year-old boy?
I'm sorry.
What if there was some 44-year-old woman who
I
was
know.
engaging in conduct that you engaged in with your 14-year-old boy?
I know, and I don't.
You know what?
I know what I did was wrong. They did a no contact order, and I put it behind me over a
There
year
shouldn't be a
ago.
need for a no contact order.
I understand that, sir.
You drove in from Chicago or Illinois, wherever DeKalb is, to meet with a 14-year-old boy. Now you deny all that. This is all because you were being a good mother and you were bringing your son to visit with this boy that he met online, and you're just being the good chaperone mother to watch over them.
I never said that, sir.
You didn't admit that the reason you came into town was so that your son can.
My son was friends with him.
And that's the reason you came into town.
Well, whatever reason did I have? I had no intention.
For you to maybe meet up with the 14-year-old boy?
No.
You didn't.
I saw him, obviously,
And
yes, sir.
you weren't alone together with him?
No, we were all together.
You didn't walk into the woods with him? This is all on video.
Okay.
You can say whatever you want to say. 'Cause
Okay.
You haven't been forthright or honest or open
I have.
since at all with the probation department. So
Okay.
I'm not going to sit here and argue with you or debate with you. Is there anything else you'd like to say?
No, sir.
Ms. Tomasic, anything else?
Nothing further, Your Honor. Thank you.
Ms. Celesti for the state?
Your Honor, prior to addressing the court, the victim's mother is here and would like to speak.
Okay, sure. I did receive your victim impact statement. I've read that, but you're certainly permitted and welcome to speak here in open court as well. So take your time and say what you'd like me to know.
Thank you, Your Honor. I just want to say that these past several months have been hell for my family. I see the defendant crying and saying, like, you know, how awful it is for her and how she just wants to go home. But it doesn't erase what my family has been through. It doesn't erase the mental impact on my son. He's gonna remember this probably the rest of his life. He's just now like starting to understand that this wasn't okay, like this wasn't real. This wasn't a real relationship. It makes me a little bit upset to hear her lie and say that the reason for her coming over 6 hours was not for her to see my son, because that was exactly the reason why she drove across state lines. As there was so much evidence that I viewed myself as well as the police and detectives between the text messages and the computer chats. She even stated that she knew what she was doing was wrong. She had said that she would go to prison, that she would lose her job, she'd lose her kids, she would be on the sex offender registry, and still the conversations kept going on and on between them about how they loved each other so much and they were going to find a way to be together after all of this. And my son actually thought that like he was in love with her and that she was in love with him. I mean, he was just a 14-year-old boy. So I personally feel like I was violated. What you said as far as how would you feel if some 44-year-old person did this to your 14-year-old kid? Like, yes, exactly. Like, Ms. Badkar is 5 years older than I am, and she's engaging in this with a child that's the same age as her child. Like, she has another child, well, an adult child that's older than my son. Like, I could never imagine trying to pursue a relationship with somebody younger than than one of my children. Like, there's just no way that anybody could know that it's not wrong, or to not know that it's wrong. So I hope that you do take into consideration, what the information that you've, reviewed, and again, it's just, I don't know if you're a parent, but if you are, like, it's just to try to put yourself in those shoes. If somebody tried to violate your child, or take advantage of them, like, how you would feel, so I just, thank
All right,
you.
thank you. Celeste, for the state of Ohio?
Thank you, Your Honor. One thing that stood out to me when I read the pre-sentence report in this case is that the defendant claimed that she was trying to mentor the victim. I think she kind of used that word or phrase repeatedly, and this is not only absurd, but it's wholly inconsistent with the evidence in this case. It defies logic to think that a 43-year-old woman who exchanged sexually explicit messages, photographs, and videos with a 14-year-old boy was acting in any way in a mentoring capacity. And the fact that she said this, I think, demonstrates a fundamental lack of understanding and accountability on her part. There's a lot of discussion about love and marriage and what their life will look like in the future. This is not mentoring. There is no world in which that could be considered mentoring a child who is around the same age as her own kid. And then to make matters worse, she schemes up this plan to come here from Chicago to meet up with the victim. The plan was to lie to the victim's parents to say that the victim would be hanging out with her son, again, who's close in age to the victim's age. And she drives here with her own family, her own kids. She rents a hotel room, and she meets up with the victim. And to continue on with this charade, this scheme, she even met the victim's parents. She met her in the parking lot. She greeted her. She chatted her up in an effort to put the victim's mother at ease about leaving him alone at the park with supposedly what was to be her son. The defendant tried to say that in the pre-sentence report that this was a family thing. However, the surveillance video depicts a very different story. It's caught on video what exactly, where they go, who's where, when. And it's not even worth contesting that the victim and the defendant were alone in the woods for a period of time. And then you see him kiss on the surveillance video. And again, it just makes things worse that she had her own kids with her. In the messages exchanged between them, you even see conversation about plans to do this again in the future. Now, luckily, this was reported to the police and stopped before it could get to that point, but there was certainly plans to do that. And then, it's upsetting to hear the defendant in her pre-sentence report really not understand the severity or the gravity of this, because even in messages with the victim, she knew it was wrong. She talks about the legal age of consent in the state of Ohio. She talks about the repercussions or consequences if she got caught, that she could potentially go to jail or under 292913B1B, Because she's been or pled to a sex offense here, she's not entitled to the presumption of community control sanctions. In the pre-sentence report, she maintains that she doesn't require any form of treatment or counseling. And even today here in court, by not acknowledging what her plan was when she came here, what she did with the victim in the woods, I think demonstrates that she has no insight into the predatory nature of her conduct or even any remorse. So the state is recommending prison. Prison's appropriate here, not only to protect the public from future crime, but also to punish the defendant. Thank you.
Thank you. This court has reviewed and considered the pre-sentence report investigation, psychological evaluation. I received a victim impact statement. I've read and considered that. I received numerous letters in support of the defendant. I've read and considered all of those. I've also considered the facts and circumstances of the offenses involved, the nature of these offenses. I've also considered the factors under 2912, factors indicating the conduct is more or less serious. Factors indicating the conduct is more serious. It's the fact that the defendant, there's 30-year age difference between the two here. Many of these cases, most of these cases we see, there's not that big of a gap between the age of the adult and the age of the minor involved. That you used your own children to facilitate this offense and used them as a charade when you came and visited. Your own child's the same age as the purported victim, not as the victim in this case. And you use them. Nothing indicates it's less serious. As for recidivism factors, there's absolutely no genuine remorse. You don't acknowledge doing really anything wrong except for sending a picture of your boob, I think is what you said. As the prosecutor alluded to, I'm not going to get into it much more, but you claim to be a mentor to him. I don't know if you think we're idiots up here, but I was able to read all your text messages that you sent, the videos that they showed. Did you? What am I supposed to just be ignoring all that?
No, sir.
You are. Is that what you consider mentoring? Sending the messages that the prosecutor just related to us? Because those are all messages that you wrote.
Yes, sir.
And that's what your definition of mentoring is. Mentoring a 14-year-old boy. You referred to this as a misunderstanding somewhere in one of the reports, I believe. Well, I don't know what we misunderstood. But there's absolutely no remorse, let alone genuine remorse. There's also significant issues here that you don't believe you need any help with or any treatment with. That you're just a caring adult that looks to help younger kids out. And this is your definition of helping them out, apparently. As for factors indicating recidivism is less likely, there's no prior convictions. You led a law-abiding life, your entire life up until this. Under 2913B1, the court notes this is a sex offense, both of these charges, which overrides any presumption for community control and permits the court to impose a prison term. Prison certainly is consistent with the purposes and principles of sentencing, and there's no way the court can make a finding you're amenable to community control sanctions. You don't think you did anything wrong, except for sending a picture of your boob, and it went way beyond that. Therefore, it'll be the sentence of this court then on count 1 and count 3, defendant serve a term in prison on each count of 9 months. I'm going to run those terms consecutive to each other for an overall prison term of 18 months in prison. You have credit for 56 days you've already served. Need to advise you upon your release from prison, you'll be placed on post-release control for 5 years. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50%, or half of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court will dismiss count 2 as agreed upon. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, transfer to transitional control. Defendant's ordered to pay all costs. Court further finds that consecutive service is necessary to protect the public from future crime by the defendant and to punish the offender, that it's not disproportionate to the seriousness of your conduct and to the danger she poses to the public, and that these two offenses were committed as a part of one or more courses of conduct, and the harm caused by these two offenses was so great or unusual that no single prison term for either of the two charges committed as a part of the course of conduct adequately reflects the seriousness of the defendant's conduct. Mr. Leslie, is there anything else I've omitted or that I need to address?
No, Your Honor. Thank you.
Ms. Thomas, on behalf of the defendant.
Nothing further, Your Honor. Thank you.
This case centers on Roxanne Badkar, who pled guilty to 2 felony charges involving illegal sexual communication and material with a 14-year-old boy, and the court moved to sentencing after reviewing reports and victim impact statements. The defense argued for leniency, highlighting her lack of prior criminal history, her role as a mother, and her emotional distress, while requesting community control instead of prison. But the prosecution emphasized clear evidence of deliberate behavior, including explicit messages, planning, travel across state lines, and deception of the victim's family, arguing that her claim of mentoring showed a lack of accountability. A key turning point came when the judge directly challenged her inconsistencies and refusal to fully admit her actions beyond sending photos, reinforcing concerns about dishonesty and lack of remorse, while the victim's mother described the long-term psychological harm to her son, strengthening the seriousness of the case. Ultimately, the judge concluded that the defendant's conduct was calculated, harmful, and not suitable for probation, especially given the age gap and use of her own children to facilitate the situation, and sentenced her to 18 months in prison with post-release supervision, emphasizing public protection and punishment. The core issue remains whether genuine accountability and acknowledgement of harm should weigh more heavily than a previously clean record when determining sentencing in cases involving minors.